The law firm of Villasis and Partners, VP Law, is a law office engaged in the general practice of law. Its principal office is conveniently located at the heart of the University Belt at Villasis Law Center, VLC, Unit 911 CKKFI Building P. Paredes Street, Sampala, Manila. VP Law was organized in 2015 by attorney Christian G. Villasis and continues to expand to date. From the start, VP Law has maintained a varied and prestigious client base and continues to be recognized as one of the leading law firms in the country. VP Law has a diversified general law practice as the firm handles all aspects of corporate, commercial and business transactions, protection and enforcement of intellectual property rights and data privacy rights, collection, civil and criminal litigation, admiralty and maritime practice, labor management relations, election, administrative and local government cases, real estate transactions, land titles, deeds and conveyances, foreclosure of mortgages, writ of possession, replevin, bought laws, business organizations and corporate regulatory compliance and taxation, among others. In addition, the firm offers contract drafting, review, and negotiation, legal research and consultation, as well as other legal assistance pertinent thereto. At present, the firm's increasing number of lawyers is capable of handling various legal matters and cases and is able and willing to cater to clients' concerns with utmost professionalism and zeal. Apart from experienced VP Law lawyers, its legal team includes highly competent paralegals and professional legal staff who are constantly inclined to assist the lawyers, thereby ensuring efficient and cost-effective service to its clients. VP Law aims to provide its clients with quality legal representation anchored on the ethics of hard work, commitment and responsiveness to clients' needs. This vision has been the moving force in the firm's growth into a first-rate, full-service law firm.
We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.
held liable for staffa by misappropriation or conversion. Okay, staffa by misappropriation or conversion. Why can't that not be theft? Why can't that not be carnapping, which is of similar nature of theft? Okay, it is because Mr. A's possession over that car is not only physical or material, it is juridical as well. For the next 7 days from the time he rented the car, okay, he not only has physical possession of that car, he has juridical possession of that car as well. Why did I say that?
The other source of labor principles is the Constitution. Do not enter the gates of USC unless you have mastered the four corners of Section 3, Article 13 of the Constitution of 1987. How important is this provision? Based on this constitutional provision, there were questions given in 1988, 96, 98. 2007, 2008, 2009, 2011, 2012. So if this constitutional provision figured in those barriers, then it means that it is a bar area that requires mastery. The first question in 1998 was this: what are the salient features of the protection?
In the Constitution that the JBC, the Judicial and Bar Council, shall be composed of 7 members. The Chief Justice as ex officio chairperson, the Secretary of Justice, very specific, as a member, ex officio member, and then a member from Congress, and then 4 other regular members, a representative from the retired Supreme Court justices, very specific, a representative from the integrated bar, a representative from the private sector, and then a representative from the academe, professor of law. This case of Chavez versus JBC, it's included in this slide. I'm sharing simply because there was an issue actually on what a member.
Unang pumaparte sa mana, BIR, kasi mayroon tinatag na estate tax. Okay? Maganda ngayon, isa na lamang ang rate, 6% na lang ng net estate. Okay? Unlike before, the computation of the estate tax was a little complicated, and long before, meron ng estate tax, meron pang inheritance tax na mas magulong po i-compute. Kaya lang, fortunately, ito panahon ni Presidente Duterte, legislature passed a law simplifying the computation of estate taxes. A flat rate of 6% of the net estate. Hindi na-graduated.
day to our dear attendees from different parts of the country. I pray that you're all in great state of health. This free webinar is streaming live via the Villasis Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of Villasis Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of Villasis Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 through any web browser, using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.villasislawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual claps and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Our lecturer is a court attorney at the Supreme Court of the Philippines, Office of the Reporter, in charge of syllabus and subject index of the recent decisions promulgated by the Supreme Court that will be published in the Philippine Reports. He is also a professor at Manuel L. Quezon University School of Law for almost 7 years teaching legal ethics, problem areas in legal ethics, legal profession, and sales. And annually conducts pre-week bar lecture at the Grand Lodge of the Philippines for Mason's Order of Law Proceedings and at MLQU School of Law. Without further ado, let us all welcome Professor Frederick Anciano.
Good day everyone, I am Professor Frederick Anciano and welcome to this free online lecture brought to you by the Virtual Law Companion of Villasis Law Center. Prepare for the bar examinations at any time, anywhere, and from any mobile device. Check out the VLC website at www.villasislawcenter.com for more details and particulars. Optimize this learning opportunity. Like the VLC Facebook and share this FB live session. Host a watch party via FB and tag your friends now, and together learn at the comfort of your homes. Before we start, please comment VLC if you can hear me clearly. Good day to everyone. So today we will be discussing about significant articles of the Civil Code relating to common carriers. So, first of all, kailangan muna natin malaman sino ba ang common carrier at sino ba ang private carrier. So, let's say for example, passenger jeep, passenger bus, passenger airplane, are they considered as common carriers? Well, they are not common carriers. Why? Because we should substantially first memorize Article 1732 of the Civil Code. Kasi ang common carriers daw, these are common carriers under Article 1732. Common carriers are persons, corporation, firms, or association. So, passenger jeep, a passenger bus is not a person, it's not a corporation, it's not a firm, neither an association. So, they are common carriers. They are persons, corporations, firms, and association engaged in the business of carrying goods or passenger or boat. Okay. And number 4, for compensation. So, bigay ko dyan pera para mas madali tandaan. And number 5, offering their services to the public. Okay? So again, under the civil code, Article 1732 is substantially memorized. So if you can see, parang limang elements siya. Okay, first is that common carriers are persons, corporation, firms, or association, and it is engaged in the business of carrying goods or passenger or boat for compensation and offering their services to the public. Now, so, ang common carriers in terms of passenger jeep, passenger bus, passenger airline are the operators. Okay, because sila yung mga corporation which is engaged in this kind of business. But what about, let's say for example, carrying goods by land, air, or water? Okay? What if, for example, oil pipelines? Of course, you know this case, the case of First Industrial. Diba? Yung oil pipelines from Manila, Pandacan, going to Batangas. So, do you think these oil pipeline operators, are they considered as common carriers? Yes, they are considered, of course, common carriers because in such case, the Supreme Court discussed that Article 1732 does not distinguish the means of transportation as long as it is by land or air or water. Okay? And then it does not provide that the transportation should be by a motor vehicle. So meaning to say, even hindi siya motor vehicle, it can still be considered as a common carrier. Why? Because, as we have discussed, common carriers are persons, corporations, firms, or association engaged in the business of carrying goods or passenger or boat by land, air, or water for compensation and offering their services to the public. So yung oil is dinadala siya through pipelines and it was considered by the Supreme Court as a common carrier. And as I want to emphasize, sabi ni Supreme Court, in the case of First Philippine Industrial, the law does not distinguish. Article 1732 does not distinguish the means of transportation as long as it is by land or air or water. And it does not provide, Article 1732 does not provide that the transportation should be by means of motor vehicle, kahit hindi daw siya motor vehicle. So this is an oil pipeline. So, pardon me for my drawing and my writing. Anyway, what about if it is without compensation? Daw. I'm referring to the case of cruise versus sun holidays. I'm talking about resort operators. Resort operator. Engaged in the business of giving a free ferry services. Free ferry services. So this case of cruise versus sun holidays, si resort operator kasama dun sa kanyang kumbaga package na dadalhin yung mga client niya from I think Batangas na tayo. Dadalhin dun sa resort niya, nasasakay yung mga client doon sa ferry services without compensation. So sasakay yung mga passenger dun sa ferry services, walang bayad. Okay? Now, it so happened in that case, an accident occurred. So, to cut the long story short, the heirs of the victim, yung, if I'm not mistaken, yung dalawang bagong kasal, so their heirs filed an action for damages against the resort operator because of breach of contract of carriage and failure to observe the diligence required, which is utmost diligence. Now, what was the defense of the resort operator? So, sabi ng resort operator, okay, hindi kami common carrier kasi yung sinasakyan na ferry services is free. Okay? So, ano ngayon ang sabi ng Supreme Court? Sabi nga ni Supreme Court, in that case of cruise versus Sun Holidays, Article 732 makes no distinction regarding the business activity of the carrier. Whether it is the principal business activity or it is an ancillary business activity, the fact that papasok siya sa elements ng Article 1732, it is considered as a common carrier. And another, it does not distinguish. Article 1732 makes no distinction as to offering of the transportation basis. Okay? Yung offering of transportation basis, regardless if it is offered to the general public or if it is offered to the narrow segment of the general public, it does not distinguish. And also, with regards to transportation basis again, regular basis man siya or occasional basis, 1732 does not distinguish. Okay, the fact that present yung elements na to, that carrier is considered as a public carrier. And also, the Supreme Court said in this cruise versus Sun Holidays case, yung free ferry services nila is not considered as free. Why? Because these ferry services are so intertwined with the main business. Meaning to say, nung nagbayad yung mga kliyente nila na pupunta sa resort, kasama na dun sa bayad sa kanila yung sa ferry services. Okay? Now, let's go now to sa public naman, offering their services to the public. Kasi there's one case, the case of spouses Parenya versus Sarate. Of course, you all know this. Yung school bus operators. In this case, yung student of Don Bosco sumakay dun sa school bus ni defendant and malilate na sila. So what the driver did was dumaan sila dun sa way na hindi naman intended for motor vehicles. They crossed the railway. The problem is that nung naghahabol itong driver ni school bus, naghahabol, paparating na yung tren, so tinamaan yung school bus. So, accident occurred, namatay yung isang estudyante. Okay? Now, of course, action for damages was filed against the school bus operator. So, what was the defense of the school bus operator? Hindi daw sila common carrier. Why? Because they only have a limited clientele. Diba? Kung sino lang yung sinusundo nila for that day, the next day, yun pa rin. The next day, yun pa rin. So, according to them, hindi daw sila common carrier. But what was the ruling of the Supreme Court? In this case, the Supreme Court make it clear that school bus operators are common carriers. Bakit? Bakit daw common carriers ang school bus operators? Sabi ni Supreme Court, the true test is not the quantity of the business actually transacted. Again, the true test is not the quantity of the business actually transacted, but whether, ito take note of these keywords, but whether the carrier has held himself out to the general public. Okay? If the carrier held himself out to the general public, in such case, the carrier is considered as public carrier. Okay? Now, what is the significance? What is the significance of determining ano naman if it is a public carrier? or it is a public carrier or a private carrier. Okay, ano naman kung kung common carrier ka, ano naman kung private carrier ka. Okay? What is the significance? Kasi first of all, if present lahat ng elements under Article 1732 and the carrier is considered as a common carrier, what law will govern? So let's discuss first the governing law. Pag common carrier ka po, ang mag-govern na law sa inyo ay yung new civil code, but chapters on common carriers, which is Article 1732 to 1766. Okay? Chapter on common carrier. So, yun yung mag-a-apply sa inyo pag common carrier kayo. Pero, pag private carrier kayo, ano mag-a-apply? Also, the new civil code, but chapters on obligations and contracts. Okay? Obligations and contracts. Now, second significance. If let's talk about diligence required. Okay? What is the diligence required sa mga common carriers? Of course, we all know, sabi ng ating civil code, if you are a common carrier, from the nature of your business and by reason of public policy, common carriers are bound to carry the passenger and to observe extraordinary diligence in the vigilance over the goods and safety of passenger. Again, from the nature of their business and from the nature of their business and by reason of public policy, common carriers are bound to observe extraordinary diligence in the vigilance over the goods and safety of passengers. So the diligence required if you are a common carrier is extraordinary diligence. On the other hand, if you are a private carrier, okay, required ba ang extraordinary diligence or utmost diligence? No, because ang required lang ay diligence of a good father of the family. Okay? Now, another distinction insofar as to the presumption. Presumption of what? Presumption of fault or negligence. If you are a common carrier, there is already in case of death or injury of passenger or in case of loss, destruction or deterioration of goods, meron kagad presumption of fault or negligence. But on the other hand, if you are a private carrier, there is no presumption. No presumption of fault or negligence. So, ay ano naman ngayon kung may presumption ng negligence or fault sa common carrier. Kasi po, fourth significance, yung tinatawag natin na burden of proof. Burden of proof. Since ang mga common carrier, meron sa kanilang presumption of fault or negligence, in case mag-file ng damages si offended party or si plaintiff, pag nag-file siya ng action for damages against sa common carrier, the burden of proof is on the common carrier. Hindi mag-a-apply yung basic rule na he who alleged must prove. Kasi nga, mayroong presumption. On the other hand, if you are a private carrier at yung pasahero mo, take note, private carrier, na aksidente, na injured, or namatay, if you will file an action for quasi-delict, okay, sino ang may burden of proof? Ang may burden of proof ay the party who filed the case, the plaintiff. He should prove that there was negligence on the part of the private carrier. And like in this case, as I have said, you can say millennial term, judgmental. Pag common carrier ka kasi may presumption kagad. At si common carrier pa ang magpo-prove na it observed extraordinary diligence. Okay? Now, I hope you're maximizing this learning session. Please tag a friend to this FB Live or host a watch party. Okay? Okay, so our next topic, let's talk about the governing laws. What are the governing laws? Okay. So before we can determine what are the governing laws, first let's ask ourselves muna if it is an overland transportation, if it is a maritime, or if it is air transportation. Okay? So bakit? Kasi if it is an overland transportation, ano ang mag-govern na laws? Of course, overland, we all know. Passenger jeeps, passenger bus, tricycle. Okay? So, pag overland transportation, ano ang ating primary governing law? So, the primary governing law is, of course, the new Civil Code. Article 1732 up to Article 1766. Okay? Ano naman ang suppletorily? What law will apply? Ang suppletory law natin is the code, yung lumang batas, yung Code of Commerce. Okay? So in case of absence of any provision dun sa new Civil Code, the Code of Commerce will apply. Okay? And after overland, let's go to maritime. Sa maritime, ano ngayon ang mga governing laws natin? First, determine if the vessel is coming from the foreign port ba or coming here sa Philippine ports. Okay? Or determine if it is coastwise shipping. What is coastwise shipping? When we say coastwise shipping, it is island to island travel. Okay? So within the island of the Philippines, yung biyahe ng barko. So pag coastwise shipping, the primary law that will govern is the new Civil Code. The same, Article 1732 up to Article 1766. And in case of absence of any provision under the new Civil Code, the supplementary law that will govern is the Code of Commerce. Okay? So this is coastwise shipping. Now what if the vessel is from a foreign port going sa Philippine ports? So foreign ports, papasok yung vessel papunta sa Philippine ports. What is the governing law? Of course, syempre, primary law natin ay ang new Civil Code pa rin, Article 1732 to 1766. But, what is the supplementary law? Supplementary law. Of course, we will apply COGSA, Carriage of Goods by Sea Act, COGSA, or the Code of Commerce. Okay? That's when the vessel is from foreign ports coming inside the Philippine ports. Primary law, new Civil Code. Supplementary law is COGSA, Carriage of Goods by Sea Act, or pwede rin mag-apply ang Code of Commerce. Now, what if yung vessel, so letter C, what if yung vessel comes from the Philippine ports, baliktad naman. From the Philippine ports, going to any foreign ports. Okay, what is the rule? What is the law that will govern? The law that will govern is the law of the country where the goods are to be shipped. Okay, so yun yung mag-govern na law. Now, when it comes to, so tapos na tayo sa overland transportation, maritime transportation, let's go to airline transportation. Okay. So when we talk about airline transportation, of course, the primary law that will govern is the new Civil Code. Supplementarily is the Code of Commerce. Now, what if it is an international airline shipping? Pag international airline shipping, what is the law that will govern suppletorily? It is the Warsaw Convention. Warsaw Convention. Okay? So these are the governing laws insofar as to transportation law is concerned. Now, queries? I hope you are enjoying this webinar. Please comment VLC. Okay, now our next topic is about vigilance over goods. Vigilance over goods. Okay. Vigilance over goods. Now, when we talk about vigilance over goods, we should first know what is the diligence required. Ano ba ang diligence required sa common carrier? Diligence required. Okay. So, when we talk about vigilance over goods, the diligence required is extraordinary diligence. Bakit? Ano bang sabi ng ating civil code? Kasi sabi ng ating civil code, from the nature of their business and by reason of public policy, common carriers are bound to observe extraordinary diligence in the vigilance over goods and safety of passengers. Okay, so the diligence required is extraordinary diligence. But of course, we should know what is the definition of extraordinary diligence. Okay? So this extraordinary diligence ano ba ibig sabihin itong extraordinary diligence? So, extraordinary diligence, this is the extreme measure of care and caution. It is the extreme measure of care and caution which persons of unusual prudence use in securing or preserving their own property. Again, this the definition of extraordinary diligence. It is the extreme measure of care and caution which persons of unusual prudence use in securing and preserving their own property. So in layman, it is as if na property ni common carrier yung goods para pumasa dito sa extraordinary diligence. Okay? Now, number 2 topic. I would like to discuss the presumption in case of loss, destruction, or deterioration of goods. So, presumption. In case of loss, destruction, or deterioration of goods. Ano ba ang presumption natin under the Civil Code? So, under the Civil Code, in case of loss, destruction, or deterioration of goods, common carriers are presumed to have been at fault or acted negligently unless the common carrier proves that it observed extraordinary diligence. Okay, so again, there is a presumption of negligence or fault unless the common carrier proves that it observed extraordinary diligence. Okay? Now, as I have said kanina, yung distinction, since mayroong presumption kay common carrier, the burden of proof shifts, or the burden of proof is on the common carrier to prove that it observed extraordinary diligence. Okay? Now, third topic, under vigilance over goods. So, let's discuss the duration. Duration of responsibility. Responsibility or liability. Meaning to say, ano ba yung period kung saan si common carrier ay dapat nag-o-observe ng extraordinary diligence in carriage of goods. Okay? Now, under the Civil Code, ano sinasabi ng Civil Code so far as to the duration of responsibility or liability of the common carrier? The extraordinary responsibility of the common carrier lasts from the time the goods are unconditionally placed in the possession of and received by the common carrier for transportation until it is delivered to the this is very important, delivered actually or constructively to the consignee or party who has the right to receive it. So, illustrate natin. So, ang duration daw kung saan dapat si common carrier ay nag-o-observe pa rin ng extraordinary diligence in carriage of goods. So, it starts, kailan siya nag-i-start? From the extraordinary responsibility of the common carrier. Last, from the time the goods are unconditionally placed in the possession of, so nasa possession of and, the conjunctive word and, received by the common carrier for transportation. So, ibig sabihin, mere possession. Halimbawa, magpapadala ng package. Itong si shipper. Nandun ngayon siya sa office ni shipper. Pagpasok niya sa office, it so happen, nadulas siya dahil may nakakalat na, let's say, balat ng saging, so nabasag yung dala niyang goods. In such case, pwede ba niya i-demanda ng damages on the ground of breach of contract of carriage si common carrier? Kailangan na ba mag-observe ni common during that time na pumasok si shipper dun sa office ni common carrier para ipapadala yung goods? Like for example, yung mga shipping company natin. Nasira yung goods. The problem is that hindi pa nare-receive ni common carrier. It so happen lang na nandun kayo sa vicinity, sa premises ni common carrier. In such case, is it obliged on the part of the common carrier to observe extraordinary diligence? Not yet. Why? Because it is not yet received by the common carrier. Sabi ng ating Civil Code, it lasts from the time the goods are unconditionally placed in the possession of and received by the common carrier for transportation. Okay? Until kailan? So what is the period? Until the goods are delivered to the consignee. Take note, delivered to the consignee. The delivery may be constructively or actual delivery. So, the delivery can be actual delivery or constructive delivery. Okay? So, until the goods are delivered actually or constructively to the consignee or party who has the right to receive it. So, during this period, the common carrier is obliged to observe extraordinary diligence sa goods na pinadala ni shipper to be given to the consignee. Okay? Now, what if during this period, let's say for example, it involves a vessel. So, isi-ship yung goods gamit ang vessel. Let's say for example, from Atty, i-deliver yung goods papunta ng Hulo, pababa. Now, what if during transit, there was temporary unloading of goods what is the rule? Kailangan pa rin ba mag-observe ni common carrier ng extraordinary diligence? Ano ba sinasabi ng ating civil code? Sabi ng civil code, the obligation of the common carrier to observe extraordinary diligence remains in full force, and it is still effective even the goods are temporarily unloaded or stored during transit. Okay? During transit. Ano lang ang exception? Ang exception is if the consignee will exercise his right. What is that right? Right of stoppage in transit 2. So, I'll just illustrate. So, halimbawa, ito po ay Pilipinas. So, it involves vessel. I-deliver, at dito kunwari, sa taas ng Pilipinas yung vessel, i-deliver yung goods papunta dito sa hulo. Okay? Now, paano kung for example, tumigil saglit, may temporary unloading or storage of the goods dito sa Palawan. Dahil kunwari, lilinisin yung vessel or whatever, lalagyan ng gas. Basta, during transit, tumigil saglit sa port. So, there was a temporary unloading or storage of goods during transit. Tapos, may nangyari dun sa goods while temporarily stored sa warehouse. Meron pa rin bang obligasyon si common carrier to observe? Meron pa rin bang presumption in case of loss, destruction, or deterioration of the goods? Yes. Kasi nga sabi ni Civil Code, the extraordinary liability of the common carrier na it remains in full force and effect. Even the goods are temporarily stored or unloaded during transit except if the consignee exercise his right to stoppage in transit 2. Ngayon, ano naman ito yung tinatawag natin stoppage in transit 2? Just to give you overview lang, stoppage in transit 2, this is a right. This is a remedy of an unpaid seller. Kasi, di ba, we all know that in case there is an unpaid seller, there are two general remedies. So, ang two general remedies, so si unpaid seller, allow me to discuss. So, si unpaid seller, ano ang kanyang dalawang general remedies? Okay, so first, the unpaid seller may file an action for specific performance. So, specific performance with damages. Or, number two, the unpaid seller may file an action for rescission with damages. Okay, but general remedies yan. But, para maipasok natin yung konseptong stoppage in transit 2, kasi sa unpaid seller, to be more specific kung anong rule yung gagamitin, we should first determine if it involves personal or movable property or real or immovable property. Bakit? Kasi if it involves personal property and the payment is payable by installment, the governing rule is direct to law. Okay? Now, if it is real property or immovable property and it is payable installment, what is the rule applicable? Of course, the Maseda law. Okay, now, what if it involves personal property and it is a sale on credit? Sale on credit. Ibig sabihin, utang, walang binayaran na hulugan, it is sale on credit. In case hindi mabayaran si unpaid seller, what are his or her remedies? Of course, number one, possessory lien, rescission, resale, and stoppage in transit 2. So, dito na mag-a-apply yung stoppage in transit 2. Ano po ang ibig sabihin yan? Ibig sabihin, probably, yung given case ko kanina, nung ipapadala na ni shipper yung goods to be transported from Apari papuntang Hulo, siguro sabi ni consignee, ni buyer, o shipper, while the goods are on transit, ita-transfer ko sa iyo yung payment. Okay? Now, nung nag-voyage na yung ship, hinihintay na ngayon ni shipper yung bayad, hindi nagbayad ngayon si consignee, and the consignee was considered as insolvent. In such case, kahit na during transit, tapos in-exercise ni unpaid seller yung kanyang right to stoppage in transit 2, in that case, wala nang obligasyon si common carrier to observe extraordinary diligence. But still, the common carrier is obliged to observe due diligence of a good father of the family. So yun po yung if the goods are on transit. What if, di ba example ko kanina from Apari going to Hulo, okay? Hindi na ngayon in transit. Nakarating na ngayon yung goods doon sa Hulo. Okay? And it was stored in the warehouse of the common carrier at the place of destination. Nakarating na dito. Siyempre, i-impact muna yan sa warehouse. So, is it still required for the common carrier to observe extraordinary diligence? Yes. Okay? It is still required for the common carrier to observe extraordinary diligence if the goods are unloaded or stored in the warehouse of the common carrier, warehouse ni common carrier, at the place of destination. Until what? Until the consignee has been given notice that the goods are already in the warehouse and that the consignee was given an opportunity to remove or receive the same. So yun yung example natin. Okay? So ibig sabihin, if dumating na yung goods dun sa warehouse ni common carrier at the place of destination, at in-inform na si consignee, oy consignee, nandito na yung goods mo, pick upin mo na. And the consignee was given a reasonable opportunity to receive or remove the same at hindi ginawa ni consignee, hindi niya na-receive. After that, wala nang obligasyon si common carrier to observe extraordinary diligence. But as I have said, kailangan pa rin mag-observe si common carrier ng due diligence of a good father of the family na lang. Okay? Now, please comment VLC if you believe that you will pass the bar examination. Comment VLC. Okay? Now, let's talk about dito pa rin tayo sa vigilance over goods. Remember, we're talking about goods, not passengers. Let's talk about the stipulation limiting the liability of common carrier. Stipulation limiting the liability of the common carrier. Okay? Yung stipulation of limiting liability of the common carrier, dalawa kasi po yan. It's Article 1744 and the other one is Article 1750. 49 and 1750. Okay? I-distinguish ko lang para huwag tayo malito. Okay? Now, ano ba yung nandun sa Article 1744? Stipulation limiting the liability of the common carrier. Yung nasa 1744 po kasi is reduction. Reduction of diligence. Okay? Reduction of diligence. Ano pong ibig sabihin niya? Di ba, basic is the rule that the diligence required in so far as to carriage of goods is extraordinary diligence. Ngayon, pwede po bang magkaroon ng stipulation si common carrier at si shipper na ang i-observe lang na diligence ni common carrier ay due diligence of a good father of the family? Reduction of diligence, pwede ba? Pwede if may tatlo po tayong requisites. Okay, so you can reduce the diligence in so far as to carriage of goods. Kasi, take note, this reduction of diligence does not apply sa safety or carriage of passenger. Kahit na present itong tatlong requisite, hindi po pwedeng magkaroon ng reduction of diligence sa carriage of passenger. Pwede lang po siya sa carriage of goods. So, reduction of diligence is valid provided that, number one, it must be written and signed by the shipper or owner. Okay? And number two, there must be a valuable consideration. And number three, it must be reasonable. Okay? So, kung present po itong tatlong to, it is written and it was signed by the shipper or the owner, and there is a valuable consideration, and it is reasonable, the reduction of diligence to a diligence of a good father of the family in carriage of goods is valid. Okay? Reduction of diligence. Ano naman po itong nasa Article 1749 at 1750? This is about fixing the liability of the carrier, the common carrier. Anong ibig sabihin po nung fixing the liability of the common carrier? Kasi sabi ng ating civil code, stipulation limiting the liability of the common carrier to the value of the goods appearing on the bill of lading is binding. So kung nakalagay sa bill of lading, liable lang ang common carriers na 1,000 per package. That is valid. Except if the shipper indicates a greater amount or value. So pag nilagay ni shipper na mas mahal yung goods niya, let's say 5,000, it is also binding. Okay? So the shipper or owner should declare a greater value para mas mataas dun sa nakalagay sa bill of lading yung makukuha niya in case magkaroon ng loss, destruction, or deterioration of goods. So yan po yung difference nila sa stipulation limiting the liability of common carrier. Take note, si 44 po ay reduction of diligence, si 49 and 50, 1749 and 50 is fixing the liability of the common carrier to a greater amount or value, provided that it was declared by the shipper. Okay? So again, I hope you are enjoying this webinar. Please comment VLC. Okay, now let's go now to our next topic relating to vigilance over goods. Number 5, my last topic is I think one of the most important. These are the defenses of common carriers. Ano ba yung mga defenses? Because the general rule is that common carriers are responsible for the loss, destruction, or deterioration of the goods unless it is caused by. So anong defenses niya? Anong palatandaan natin? Sulat mo na lang siguro is FAACO. FAACO. Parang social na FICO. FAACO. So, general rule, in case of loss, destruction, or deterioration of goods, common carriers are liable unless it is caused by, number 1, tinatawag natin na fortuitous event. Unless if it is caused by flood, storm, earthquake, natural calamity, or disaster. That's number 1. Number 2, unless it is caused by the act or omission of the shipper or owner. Okay? Number 3, unless it is because of the act of a public enemy during war. Number 4, what is C? C is unless it is caused by the character of the goods or the improper packing. And the last one, letter O, is the order or act of a competent authority. Order or act of a competent authority. Okay? Now, I just want to discuss kasi dito lang naman may laging lumalabas na tanong sa bar yung about this. Si F. Sino to? Si fortuitous event, si flood, storm, earthquake, natural calamity, or disaster. Kasi ibig sabihin ba niya pag mayroong natural calamity, may flood, may storm, nasa vessel, dala-dala yung goods, at nagkaroon ng bagyo, typhoon, nasira yung goods, does it necessarily mean that the common carrier is excused? No, the common carrier is not outrightly excused. Why? Because there are qualifications before the common carrier can be excused because of this fortuitous event, this natural disaster or natural calamity. And what are those? Okay, number one is Article 1739. Okay, Article 1739. Number two is the Act of God doctrine. And number three is the Article 1740. Article 1740. So ano pong ibig sabihin nito? Ang ibig sabihin po nito, if the common carrier will have a defense of fortuitous event, natural calamity, or disaster, hindi ka agad exempted si common carrier. Why? First, kailangan pasok siya sa 1739. Anong ibig sabihin? Anong sinasabi sa 1739? The natural disaster or natural calamity must be the proximate and only cause of the loss, destruction, or deterioration of the goods. Okay? Again, yung natural calamity, natural disaster, the fortuitous event must be the proximate and only cause of the loss, destruction, or deterioration of the goods. And the common carrier must prove that it exercised due diligence to stop, forestall, or minimize the loss, destruction, or deterioration of the goods before, during, and after the natural calamity or disaster. Okay? So take note, pag may fortuitous event, kailangan merong burden si common carrier to prove that the natural disaster or calamity or fortuitous event is the only and proximate cause of the loss, destruction, and deterioration of the goods. And also, the common carrier must prove, ano ipoprove ni common carrier? That it exercised due diligence to stop, minimize, forestall the loss, destruction, or deterioration of the goods before, during, and after the natural calamity. So kung pasok na doon, let's go to the second qualification. Kailangan mag-apply ang Act of God doctrine. Okay, ano ba itong Act of God doctrine? There must be, ibig sabihin ng Act of God doctrine, there must be exclusion of human agency. Okay? There must be exclusion of human agency. Anong ibig sabihin po nun? The act must be occasioned solely by the violence of nature para mag-apply ang Act of God doctrine. Again, kailangan may exclusion ng human agency, meaning to say, the act must be occasioned solely by the violence of nature. And sabi rin ni Supreme Court in several cases, in order for the Act of God doctrine to apply, it is not enough that the accident was caused by a fortuitous event because the common carrier must still prove that it did not contribute to the occurrence. So this is the keyword sa Act of God doctrine. Kailangan walang human intervention. Kasi if there is human intervention, whether active participation or negligence, the occurrence becomes humanized. And if it becomes humanized, it will the doctrine of Act of God doctrine will not be applicable. Again, kailangan walang human intervention. When we say human intervention, it's either active participation or negligence. Kasi if there's an active participation or there is negligence on the part of the employees of the common carrier, it becomes humanized. And if it becomes humanized, the Act of God doctrine will no longer be applicable. Okay, that's number two. Number 3, para sigurado tayong exempted si common carrier because of fortuitous event, natural calamity, or disaster. Number 3, there must be no delay. But take note, under 1740, the delay must be negligently incurred in delay. Meaning to say, yung pagka-delay ni common carrier was not negligent on his part. Okay? So, take note of the word negligent. Kasi pag delay but there is a lawful reason bakit na-delay si common carrier, maaari pa rin pumasok ang defense ng fortuitous event or natural disaster or storm, earthquake, lightning. Of course, basta present si 1739 and mag-a-apply yung Act of God doctrine. Okay. Please comment VLC if you believe that you will pass the bar examination, and I hope you are enjoying this webinar. Comment VLC sa comment section. Okay. Now, let's go now to my last topic. Okay. My last topic is about safety of passengers. Okay, so when we talk about safety of passengers, of course, let's discuss first, ano ba yung diligence required? Katulad kanina sa carriage of goods. Ano ba yung diligence required? Okay? Sa safety of passenger, the diligence required is, of course, utmost diligence. Because sabi ng ating civil code, although nga pala, utmost diligence is the same with extraordinary diligence. Okay? Kasi sabi nga ng civil code natin, from the nature of their business and by reason of public policy, common carriers are bound to observe extraordinary diligence in the vigilance over the goods and safety of passengers. But sa cases, ang ginagamit ng Supreme Court when we're talking about safety of passengers is utmost diligence. Okay? Ang rule kasi natin dyan, common carriers are bound to carry the passengers safely as far as human care and foresight can provide using the utmost diligence of a very cautious person with due regards to all the circumstances. So yun yung specific article na ina-apply ng Supreme Court if the issue is about safety of passenger. Again, common carriers are bound to carry the passengers safely as far as human care and foresight can provide using the utmost diligence of a very cautious person with due regards to all the circumstances. Okay, so that's the diligence required. Next, let's talk about, syempre, presumption ulit. Presumption. Ano ba ang presumption? Kung kanina sa carriage of goods, ano ba ang presumption in case of LDD? In case of loss, destruction, or deterioration of goods? So, fault and negligence. Same thing dito sa safety of passenger. The presumption in case of, ano naman dito, death or injury. So, in case of death or injury, it is presumed that the common carrier have acted negligently or is at fault unless the common carrier proves that it observed extraordinary diligence. Okay? But take note of the case of Sulpicio Lines versus Atty. Sulpicio Lines versus Atty. Bakit? Kasi sinabi ni Supreme Court in that case that before the presumption of negligence or fault on the part of the common carrier, meron munang duty si plaintiff or si offended party. Okay? In the case of action for damages, meron munang duty si plaintiff. And what is that? Two duties. Number one, he should prove first that there is an existence of contract of carriage. The plaintiff should prove in his allegations that there is a contract of carriage. And number 2, that the injury or death occurred during the existence of the contract. After ma-prove ni plaintiff yan, yung presumption will go to the common carrier. Ano yung presumption? Yung presumption na negligent siya or he acted at fault. And in such case, si common carrier, he should prove that inobserve niya yung utmost diligence. Okay? Now next, let's talk about the duration of responsibility or liability. Okay? Kung kanina po sa vigilance over goods, mayroong specific article sa Civil Code na sinasabi kung ano ba yung period na dapat i-observe ni common carrier, yung diligence, extraordinary diligence, di ba sabi sa Civil Code, to remind you, yung duration of liability or responsibility insofar as to carriage of goods is that the extraordinary responsibility of the common carrier lasts from the time the goods are unconditionally placed in the possession of and received by the common carrier for transportation until it is received actually or delivered actually or constructively to the consignee or person authorized to receive it. Meron specific articles sa Civil Code. But when we talk about safety of passenger, walang nakalagay. So, ano ngayon ang magiging legal basis natin if we talk about the duration of responsibility? Jurisprudence enunciated by the Supreme Court. Okay? So, to illustrate, to make it simple, gawin natin ganito. Okay? So, when we talk about the start of the responsibility of the common carrier, let's say boarding of passenger. Okay? Boarding of passenger. Okay, so boarding of passenger, ano ba yung leading case natin dyan? Let's say, sasakay yung, so doon tayo magsisimula, boarding of passenger, sasakay pa lang si pasahero. Meron ba tayong kaso relating to that? Of course, yes, and we all know this, the case of Dangwa Transport. Okay, so ano nangyari dyan? Nasakay pa lang si passenger, kakaapak pa lang niya sa platform, umandar si bus. Pag-andar niya, of course, na-aksidente siya. Now, a case for action for damages was filed against the common carrier. And ano syempre ang magiging defense ni common carrier? Hindi pa po namin pasahero si victim. Kasi kakasakay pa lang niya sa kakaapak pa lang niya sa platform, sa istribo. So hindi pa namin siya pasahero. So we are not yet required to observe utmost diligence. Okay? So ano ngayon ang explanation ni Supreme Court in the case of Dangwa? Sabi ni Supreme Court, if the passenger manifests, so si passenger, if the passenger manifests his intention to board, okay, ano ibig sabihin nun? Kung may isang pasahero sa sidewalk, okay, pinara niya, tinaas niya yung kamay niya para parahin yung bus or yung jeep or yung tricycle, sa case may be. And the vehicle of the common carrier, so si common carrier or yung vehicle niya, manifests its intention to accept. So in such case, the person is already a passenger. Okay? So again, if si pasahero manifests his intention to board, pumara siya, and si motor vehicle of the common carrier manifests its intention to accept the passenger, on that instance, the person is already a passenger. Like in this case, pagkapara ni victim, pag-apak niya dun sa stribo, pasahero na siya. So, kung pasahero na siya, at merong injury or death, there is already a presumption of negligence. Kasi, on the part of the common carrier. Kasi, the common carrier should observe utmost diligence from that moment. Now, from that moment, pag si person na umapak na sa stribo, na considered na siya as passenger, ano ngayon ang sinabi ni Supreme Court in the Dangwa case? Sabi ni Supreme Court in the Dangwa case, the requirement is that the common carrier should stop their conveyances. The common carrier should stop their conveyances within a reasonable length of time to afford the passenger the opportunity to alight. Okay, again, pag ang pasahero ay nagpumara, shows his intention to board, and the common carrier stops and accepted the passenger. In such case, the common carrier, wag kagad paanda rin ni bus or ni jeep. Wag kagad niya paanda rin. Kasi sabi ni Supreme Court in the case of Dangwa, the common carrier has the duty to stop their conveyances within a reasonable length of time to afford the passenger an opportunity to board. Okay, so that's the doctrine enunciated by the Supreme Court in the case of Dangwa. To stop their conveyances within a reasonable length of time to afford the passenger to board. Okay? So yun, yung boarding of passenger, pagpasakay, the leading case is Dangwa. Now, what about in case of the passenger arrived at the destination? Arrival at the destination. Okay? Pag dumating na si passenger within the premises of the common carrier, is there a requirement on the part of the common carrier to observe extraordinary diligence or utmost diligence? Well, the leading case here is the case of LRTA versus Navida. Not Natividad, Navida. Navidad pala, sorry. The case of LRTA versus Navidad. So, magki-Christmas na. Parang ganun din, Feliz Navidad. In the case of LRTA versus Navidad, ano bang nangyari dyan? So, ito si passenger, pumunta siya ng LRT, bumili siya ng token. So, dati token pa, hindi katulad ngayon card na. Pag bili niya ng token, okay, nandun siya ngayon sa platform ng LRT. So, medyo nakainom ata yung passenger na yun. Nag-away sila ng security guard ng LRT. So, nung nag-away sila, nalaglag ngayon yung pasahero dun sa riles, nasagasaan ng tren. Of course, the heirs of the victim filed an action for damages against LRTA. Now, again, ano ulit ang defense ng LRTA? Same thing as Dangwa. Hindi pa daw nila pasahero si victim, sabi ni LRT. Kasi kung titingnan mo yung layman, hindi pa siya nakasakay sa LRT. Nandun pala siya sa platform. Okay? So, meron na bang duty si LRT to observe extraordinary or utmost diligence kahit na nandun pa lang siya sa platform si passenger? Sabi ni Supreme Court, this is the decision of the principle enunciated by the Supreme Court. Yes, the common carrier has the duty, has the requirement to observe extraordinary diligence. Not only during the course of the trip, hindi lang kahit hindi pa nakasakayan dun sa motor vehicle, because the common carrier has the duty to observe extraordinary diligence not only during the course of the trip, but as long as the passenger is, this is the keyword, within the premises of the common carrier, and number two, that the passenger is ought to be there in pursuance of the contract of carriage. Okay, so yun yung po yung sinabi ni Supreme Court sa case ni LRTA versus Navida. Sabi ni Supreme Court, hindi lang sa pagsakay or during the course of the trip or the voyage, Hindi lang doon i-exercise ni common carrier yung utmost or extraordinary diligence. But also, as long as the passenger is within the premises of the common carrier and the passenger is ought to be there in pursuance of the contract of carriage. So, hindi lang nandun si pasahero para tumambay, nandun kasi siya dahil sasakay siya. Okay? So, that's the requirement on the part of the common carrier if the passenger arrives at the destination or arrives at the premises of the common carrier. Okay? Now, when does the contract of carriage ends? When does the contract of carriage ends? So, our two leading cases here is the case of La Mallorca and Aboitiz. So, in these two cases, the Supreme Court discussed when does the contract of carriage ends. So, let's go first sa case ni La Mallorca. So, sa La Mallorca, di ba, nasa bus yung family, pagdating nila dun sa destination, bumaba ngayon yung pamilya, and then naalala ni father, ni tatay, na meron pala siyang naiwang bayong. So pagkababa nila, bumalik si tatay dun sa bus, and unknown to him, sumunod pala yung anak niya, na hindi niya alam. Nung sumunod yung anak niya, umandar ngayon yung bus, so nasagasaan yung bata. Okay? So of course, a case for damages was filed against the common carrier, and again, what was the defense of the common carrier, La Mallorca in this case? Same thing sa DAMWA, saka sa LRTA. Sabi ni common carrier in La Mallorca, hindi na po namin pasahero yung bata kasi nakababa na sila. Okay? So, in this case, what was the ruling of the Supreme Court? When does the contract of carriage ends? So, in the case of La Mallorca, sabi ni Supreme Court, the relation does not end or does not cease the moment the passenger alights. Again, the relation of the common carrier and the passenger does not cease or is not terminated the moment that the passenger alights. Why? This is very important because it continues until the passenger had a reasonable opportunity to leave the premises of the common carrier. Okay, again, the doctrine enunciated by the Supreme Court, in the case of La Mallorca, the relation of the common carrier and the passenger does not cease or is not terminated the moment the passenger alights from the motor vehicle. But it continues until the passenger had a reasonable opportunity or reasonable length of time to leave the common carrier's premises. So yun po yung sinabi ni Supreme Court in the case of La Mallorca. Now, in this case of Aboitiz, so kung dito sa La Mallorca, pagkababa ni family, kasama si father, bumalik agad si father, sabi ni Supreme Court, passenger pa rin, yung bata, nasagasa, kahit na nakababa na. Kasi nga, dapat nagkaroon ng reasonable opportunity or reasonable length of time for the passenger to leave the premises of the common carrier. But in this case, in the case of Aboitiz, nakababa na si passenger. Problem is that more than 1 hour na siyang nakababa. At anong nangyari pagbaba niya dun sa barko? May nakalimutan siyang bagahe. So bumalik siya. Pagbalik niya after 1 hour, nung tinuturo na niya yung bagahe niya, mayroong crane ni Pioneer, stevedoring. Yung crane, accidentally, tinamaan siya sa ulo. Okay, so namatay siya. So again, to cut the long story short, the heirs filed an action for damages against the common carrier, against Aboitiz. Again, ano ulit yung defense ni Aboitiz? Same thing sa DAMWA, LRTA, and La Mallorca. Hindi na po namin pasahero si victim. Kasi nakababa na siya for more than 1 hour. Okay? Ano ngayon yung sabi ni Supreme Court? Sabi rin nga pala ni Aboitiz, in this case, the case of La Mallorca will not apply in our case. Kasi sa La Mallorca, kakababa pa lang. In our case, it is more than 1 hour nung nakababa si pasahero, kaya hindi na siya namin passenger. Anong sabi ngayon ni Supreme Court? still the victim in this case is considered as a passenger because the presence of the victim within the premises of the common carrier is not without cause. Ibig sabihin, kaya nandun si passenger, there is a cause. Why? Because in terms of vessels or passenger ship, it takes at least 1 hour to get out of the premises of the common carrier. So again, ang sabi ni Supreme Court, still the victim in this case is considered as a passenger. Why? Because the presence of the passenger in this case is not without cause. It is not without cause. Okay? So that's the duration of liability. Okay? Now, I think that will end my 1 hour lecture. So I hope you learned something, and thank you for watching and for staying until the end of my presentation. Please visit the website at www.villasislawcenter.com to know more about the virtual law companion and prepare for the bar examinations at any time, anywhere, and for any mobile device. Together, we can. Thank you and God bless.
he may be held liable for estafa by misappropriation or conversion. Okay, estafa by misappropriation or conversion. Why can't that not be theft? Why can't that not be carnapping, which is of similar nature of theft? Okay, it is because Mr. A's possession over that car is not only physical or material, it is juridical as well. For the next 7 days from the time he rented the car, okay, he not only has physical possession of that car, he has juridical possession of that car as well. Why did I say that?
The other source of labor principles is the Constitution. Do not enter the gates of USC unless you have mastered the four corners of Section 3, Article 13 of the Constitution of 1987. How important is this provision? Based on this constitutional provision, there were questions given in 1988, 96, 98. 2007, 2008, 2009, 2011, 2012. So if this constitution provision figured in those barriers, then it means that it is an area that requires mastery. The first question in 1998 was this: what are the salient features of the protection?
Provided in the Constitution that the JBC, the Judicial and Bar Council, shall be composed of 7 members. The Chief Justice as ex officio chairperson, the Secretary of Justice, very specific, as a member, ex officio member, and then a member from Congress, and then 4 other regular members, a representative from the retired Supreme Court justices, very specific, a representative from the integrated bar, a representative from the private sector, and then a representative from the academe, professor of law. This case of Chavez versus JBC, it's included in this slide. I'm sharing simply because there was an issue actually on what a member.
Unang pumaparte sa mana, BIR. Kasi mayroon tinatag na estate tax. Okay? Maganda ngayon. Isa na lamang ang rate. 6% na lang ng net estate. Okay? Unlike before, the computation of the estate tax was a little complicated. And long before, meron ng estate tax, meron pang inheritance tax na mas magulong po i-compute. Kaya lang, fortunately, ito panahon ni Presidente Duterte, legislature passed a law simplifying the computation of estate taxes. A flat rate of 6% of the net estate. Hindi na graduated.